we thank you so much for watching Law School Made Easy at Law School Made Easy 256. I want to ask you to double check if you have subscribed, and if you have not subscribed, kindly subscribe to our channels. There are two channels, both of them, Voices of the Bar and this very channel, Law School Made Easy. So I want to discuss a question today, and that question is, it goes, discuss Uganda as a constitutional state. Discuss Uganda as a constitutional state. So, when you are asked such a question, that discuss Uganda as a constitutional state, of course we know what Uganda is, but the first thing that must come to your mind is what is a constitutional state. Okay? Now, constitutional state, it is also the same as constitutionalism. So what comes to your mind is that a constitutional state is where political order, okay, where the power of the government is derived and limited by the constitution. That the power of government is derived and limited by the constitution. In other words, that state, they're asking you, does Uganda follow the constitution? Okay? Does Uganda follow the constitution? That's the question. Now, they're asking you, tell us instances that show Uganda follows the constitution. Show us incidents that when somebody looks at Uganda, they can say that Uganda is a constitutional state. That's what they're looking for. Tell us the incidents that if somebody looks at them, they ably say Uganda is a constitutional state. Okay. Now, we know there are parameters how constitutionalism has been shown and discussed. The first point you must discuss is that, one, Uganda in 1995 promulgated a constitution which we call the 1995 Constitution. We promulgated a constitution. Uganda is being led by a constitution. There is a constitution they follow. Before you even go into discussing the articles which are in the constitution, the first thing is there is a constitution that was promulgated that everybody swears, affirms to uphold, to keep to the letter. Okay, so that is the first point. That one, we have the 1995 Constitution. However, before I even go, we shall discuss also some of the failures. Much as we have the Constitution, but there are incidents where the Constitution has been violated, where those principles in the Constitution have been violated. So in your essay, you can highlight the failures of Uganda as a constitutional state. There are areas where there is, you can't say because we have a constitution, it is 100%, we are just flowing, everything is working on good. You know, you just can't say that. So we have said that your first point would be that we have the 1995 Constitution. Okay? So, then you look at those other elements, principles in the Constitution that show really Uganda is a constitutional state. Let's begin with the second one, which we call supremacy of the constitution. You even state it categorically that Article 2(1) of the Constitution provides for supremacy, that the Constitution shall be the grand norm. Then if you go to Article 2(2) of the Constitution, it even says that any law or custom that is inconsistent with any of the provisions of this Constitution, that other law or custom, to the extent of its inconsistent, shall be declared void. So, when you have such an article, supremacy of the Constitution, it continues to tell you that much as we have the Constitution, it is the supreme law of the land. All this, you are trying to assert the point that Uganda is a constitutional state. So you give examples where the Constitution has emerged as the supreme law of the land. For example, look at the case of Andrew Mwenda and another versus Attorney General, where the quotation was about the offense of seditious citation, seditious intention, and seditious offense. Okay? Section 39(1)(a) and Section 41(b) of the Penal Code. They were scrapped off in the Constitution, in the Penal Code, citing that they were inconsistent with the provisions of Article 29 of the Constitution. You see, we have a Penal Code, which is an act of Parliament, and the court is scrapping off seditious intention and seditious offense in the Penal Code because they were inconsistent with the provisions of Article 29. Because seditious intention meant that you were not supposed to encroach on the peace of the president. You don't talk about the president. Yet Article 29 of the Constitution provides that everybody has a freedom to speech. Okay? So when you have such an offense, then you are curtailing the freedom of speech of the people of Uganda under Article 29 of the Constitution. Therefore, Section 39(a) and Section 41(b) were scrapped off of the Penal Code, citing that they were inconsistent with the provisions of the Constitution. Look at also the case of law advocacy, where adultery, Section 154 of the Penal Code, was scrapped off, citing inequality, discrimination. They were inconsistent with Article 21 of the Constitution. Adultery was scrapped off, being inconsistent with Article 21 of the Constitution. So you cite a case in that regard. So let's go to the other aspect. Number 2, separation of powers. That separation of powers is one of the indicators that we have a constitutional state. Okay? Let's take an example. What we mean by separation of powers, that every arm is on their own. Now, our Constitution, under Article 77 of the Constitution, creates the legislature, and its role is to make laws. Okay? And then under Article 129, the creation of the courts of judicature. Then Article 98 creates the executive. You see, these are the very important arms of government. Now, here you discuss each one of them on its own. But what we need is to discuss the article which creates it, and then you discuss the role it plays under Article 79(1). For example, if you're discussing legislature, that the legislature, there is separation of powers. This shows, now, in a state where there is constitutionalism, if you want to say that Uganda is a constitutional state, there must be separation of powers. Like Montesquieu says, I urge you to look out for my video on separation of powers. It is here. Then you appreciate what we mean by separation of power. Now, Montesquieu says that these people should be on their own, independent. But of course, there is an element of checks and balances which makes it interdependent. But now we are saying, discuss the legislature alone. Legislature, executive, and judiciary. That because each one of them is working on its own, they are all independent but interdependent. It means that there is constitutionalism. So you cite the article which forms it, 77, the legislature, and the article 79, which gives it its obligation. And then you cite article 98, which creates executive, and article 99, which discusses its function, and then you cite article 129, which creates the courts of judicature. Okay, those are now, we have discussed the 1995 Constitution being promulgated as one point. Second point, we have discussed supremacy. Third point, we have discussed legislature. Fourth point, we have discussed executive. And fifth point, we have discussed the courts of judicature, which is the judiciary. Then let's go to the aspects of human rights. Even here, I'm going to get like 34 articles you can write in your essay. Now, human rights. The Constitution has given us the whole chapter 4 that clearly talks about human rights. Okay? Now, under there, we have incidents. Let's say Article 21 talks about discrimination. The Constitution prohibits discrimination. They talk about Article 22, which preserves life. This is very important. The Constitution preserves life. Okay? So, you can discuss this in line with Amini's regime. Okay? Where people were killed. Okay? And then you bring the case of Susan Chigula and 400 others versus Attorney General, where death has a punishment was discussed, and the issue was that when you sentence people to death, you must execute there and then. If you leave them, you are subjecting them to torture. You are violating Article 24 of the Constitution, which talks about inhuman treatment. Okay? So, the Constitution preserves the life of these people. The Constitution preserves the property under Article 26 of these people. So under here, we want you to pick Article 26 of property, Article 22, life, 21, equality, and 24, and then 28, fair hearing, vis-a-vis the arbitrary arrest which used to be in the regime of Amin. Okay? So 28 are called fair hearing, and then you also pick Article 29 and also 23. Okay? You discuss them extensively. All these articles, I have done them on Law School Made Easy. There is an article, there is a video which says human rights chapter 4. So if you look for that video, all those articles, I have discussed them with the cases in them. So just look for that video of human rights, which has all the cases on each article I've told you to use. You just pick the article and you put it there. Then finally, we have the checks and balances. Okay, checks and balances means that the executive the judiciary and the legislature, they check each other. They check each other, okay? That they are not totally independent. So for a country to show that it has constitutional state, you must prove there are checks and balances. I'll give you an example. Under Article 100 of the Constitution, yes, the president, under Article 100, the president, stand to be guided. Yes. Under Article 100, you will see the president is supposed to notify the speaker and the chief justice whenever he's leaving the country. Okay? That is a check on the executive. It is a check on the executive. Okay? Then if you go to under Article 101, presidential address, that after every, I think, year, the president is supposed to address parliament, where all the arms are present. It is also a check that they don't leave you to work on your own, they check you. Because if you say, I'm a president, where do I inform people when I'm moving out? You just move out and go, but no, they are saying, check. Look at Article 142 of the Constitution, where the judiciary vets people. After doing that, then the president appoints them. Let's confirm. 142 of the Constitution. Yes, I'm here. Appointment, the Chief Justice, Deputy Chief Justice, and the principal judge shall be appointed by the president acting on the advice of Judicial Service Commission with the approval of Parliament. You see, they shall be appointed by the president under 42 on the advice of the Service Judicial Commission approved by Parliament. It's a check. It's a check. Okay? So, checks and balances. You give those articles of checks and balances. Okay? So, I urge you to look for that video of separation of powers where I've discussed all those articles. Look at 104. I think around 5. Clause 5. Where they say, the Parliament shall make the laws, but is sent to the president to assent to them. Okay? They are checking the powers of Parliament. President will approve them. So that's what we mean by checks and balances. And very many articles. 108. 108A. Appointment of the Prime Minister. 108. Appointment of the Vice President. 113. Appointment of ministers, and 111. Okay? But all those ones, the presidents appoint them and Parliament approves them. You see, they are checking the powers of the president. Parliament can so to Mugobi. You understand? So you take it in that way. So we have agreed that we are writing about checks and balances, separation of powers. Under here you talk about legislature, executive, judiciary, then human rights. We have agreed Article 21, 22, 26, 24, 28, 23, and 22. Then we go to the other one was, we have done human rights. Then you go to supremacy, and after supremacy, we discuss the last one, which was the promulgation of the 1995 Constitution. We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our videos. Until next time, cheers.